Yes, let's deal with the ruling which was for today. Who is for the second respondent?
My name is Dan Tamari for the second respondent. I will hold brief for Mr. Ishwan Jaribu for the third respondent.
These are extradition proceedings affecting 3 respondents pursuant to notice of motion application dated 16th of February 2026, filed by the prosecution. Before the hearing began, 2 issues cropped up. First, there was an application for bond pending hearing of the extradition proceedings. Secondly, and on behalf of the second respondent, Mr. Omari filed preliminary objection on the point of law dated 5th of March 2026 as follows. 1, that the notice of motion application dated 2nd of March is incompetent and bad in law, as it is an affront to the existing law on treaties. That order sought in the notice of motion application dated 2nd of March 2026 cannot be issued for reason that there is no legally recognizable legal instruments in the form of an extradition treaty between Kenya and the United States of America pursuant to Treaty Making and Ratification Act. The court then gave directions that both applications will be heard simultaneously, beginning with preliminary objection, and parties were given leeway to file their submissions. I'll start with preliminary objection. The locus classicus matters preliminary objection was raised in the case of Mukisa Biscuit Manufacturing Limited versus West End Distributors, 1968 year, and what amount to constitute preliminary objections was explained as follows, and I quote: a preliminary objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and if argued as preliminary objection, point may dispose of the suit. Examples are objection to the jurisdiction of the court, plea of limitation, or submission that a party are bound by contract giving rise to the suit to refer the dispute to arbitration. It was also held further that a preliminary objection is in the nature of what used to be demurrer. It raises pure points of law, which is argued on the assumption that all facts pleaded by the other side are correct. It cannot be raised if any fact has to be ascertained or if what is being sought is an exercise of judicial discretion. Reading from this, preliminary objection raises pure point of law, which is argued on the presumption that all facts pleaded by the other side are correct. It's also clear that it cannot be raised if any fact has to be ascertained or what's being sought is an exercise of judicial discretion. Turning to the submissions by parties on appeal, Mr. Omari submitted that the extradition proceedings is provided under Section 7, 9, 12, and 14 of Extradition Act and Convention on the Cybercrime, 2001. That convention falls under Treaty Making Ratification Act and must follow 3 processes: general responsibility of treaty initiation of treaty making process, and ratification. It was submitted that it must be taken to cabinet for approval, and the treaty has not been considered by Parliament, which grant full powers. In support, Mr. Kinyanjui submitted that there is no extradition agreement between Kenya and United States, and that all the parties, and that not all treaties are conventions. That the customary usage of convention does not in any way negate the fact that by treating convention as a treaty, there will be a rollback towards its purpose on convention on crimes. Finally, that there must be ratification, and without it, it is akin to flocking dead horse. Mr. Wambui also invited this court to see signatories, and that it's clear that Kenya has not ratified that convention. Again, Mr. Umbeta submitted that the process up to cabinet meeting had not been followed and Parliament has not ratified. Mr. Nyaribo, while associating himself with the submissions made, argued that only treaty which has been ratified can be used in court, and that the court should stop excesses by government. Mr. Ochel submitted that Kenya and US are not parties to Cybercrime Convention, and that parties are bound by their pleadings. Further, the treaties expire after 10 years as provided, and finally, that intends to use conventions, parties must make a choice or select, and Kenya has not made that selection. And in a rejoinder, Mr. Whitty for the state submitted that this court lacks jurisdiction to determine whether statute is in contravention of the Constitution, as it is a preserve of the High Court, and that the court cannot assess ratification process. Again, that extradition is based on a memorandum of understanding, and there is an agreement ended between Kenya and US that the extradition is based on treaty. It was submitted that application is grounded on United Nations Convention on Organized Crimes, and that Section 2 of the Treaty Making and Ratification Act defines ratification to include acceptance, approval, accession, and that the United Nations Convention was acceded to on the 16th of June 2024, and the UN signed on 13th of December 2000, and it was ratified in 2005. It was, again, the set submissions that both parties have ratified the conventions and the offense committed as extraditable. Determination, I have considered the preliminary objection raised, submissions made in support and also in opposition. The main issue is whether there is legal basis for extradition proceedings. The applicant argued that extradition is based on Cybercrime Convention, which has not been ratified, and there is no treaty between Kenya and USA to facilitate the process. It was submitted that the treaty has not been presented before Cabinet for approval and Parliament for ratification. And there was a response from the state that they are relying on the United Nations Convention on Organized Crime, which both Kenya and the United States of America have signed. The parties are reading from different scripts on which convention and treaty are applicable. It will be premature for this court at this stage to decide exhaustively without hearing the parties on the conventions and treaties which are relevant. It also applies to the question as whether the parties have signed or ratified the convention and treaties. There is also another issue which was raised, whether convention is a treaty and vice versa. Some facts also relates to signatories and processes of ratification, which again need to be ascertained. And in my view, this can only be ascertained at the hearing stage. It is therefore clear, and reading from the case which I had cited above, that the preliminary objection cannot be raised if any fact has to be ascertained. The issue is as to whether there exist legally recognizable legal instruments is a contested one. And on that point, I dismissed preliminary objection dated 5th of March 2026. Bail application.
March.
That's the second application. The state again, through Mr. Whitty, routed for denial of bond, relying on affidavit sworn by Inspector Nicholas Singiki on the 2nd of March 2026. It was submitted that there is compelling reasons identified under paragraph 20 and 21 of the supporting affidavit, that considering the nature of extradition proceedings, there is high likelihood that the respondents will flee even to countries which does not have the extradition agreements or treaties with either Kenya or United States of America. Further, that there is a reciprocity requirement that Kenya surrender fugitives to countries with extradition agreements. A denial of bond terms at this juncture follows diplomatic and international obligations. It was further submitted that the offense in US is serious and attract a penalty up to 30 years incarceration. Finally, that it's unsafe to release the respondent at this stage. There was response from counsel for the respondents, and Mr. Ochel, in response, submitted that there are no compelling reasons given, and the person facing extradition proceedings maintains all the rights, that with the red alert, there is nowhere the respondent will escape to. Further, that this is a charge of conspiracy, having 5 years maximum penalty, and this one may include fines. There is an issue of fines and also mitigation, which will have to be considered. It was his submission that serious offenses of murder attract bond, and the court will need to consider all the circumstances. Mr. Umpeta, for the second respondent, also submitted and cited the case of Susan Kaluki vs. Republic and others, that the respondents were granted bond, and it was affirmed up to the Court of Appeal. That this is a planned statement of likelihood with no materials placed before courts. There is no evidence, that there was no evidence of preparation to escape, and it is criminal offense to interfere with witnesses. Finally, that the respondents are ready to appear in courts and can deposit passports. Mr. Wambui also submitted that the prison facilities does not contemplate detention of suspect for long, and that they are not convicts to be detained in prison. Mr. Omari urged this court to consider war in Iraq and US, and that Kenya may be harmed in the process. Mr. Nyaribo, for that respondent, said that the respondent is not a flight risk, and Kenyan and US can get anybody anywhere, including even a banker. That the amount of 130 million for his client is big, but not outrageous, and they may need to cross-examine the deponent. I have considered the submissions on bond bail. The law is Article 49, 1H of the Constitution, and provide that every accused person has a right to be released on bond bail on reasonable conditions pending charge or trial, unless compelling reasons not to be released been given. The compelling reasons are espoused under Section 123A of the Criminal Procedure Code, and there are several other issues the court will consider: nature of seriousness of the offense, character, antecedents, and association, community of ties of the accused person, the defendant's record in respect of fulfillment of obligations under previous grant of bail, strength of the evidence, and a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person has previously been granted bail and failed to surrender to custody. And if released on bail, whether or not subject to condition, it is likely that he will fail to surrender to custody. In the case of Republic versus Shoktan Mayende and 3 others, this is a Bungoma High Court criminal case number 55 of 2009. The court described compelling reason using the following words, I quote, "The phrase compelling reason will denote reasons that are forceful and convincing as to make the court feel very strongly that the accused should not be released on bond. Bond should not therefore be denied on flimsy grounds, but on real and cogent grounds that meet the high standard set by the Constitution." End of the quote. I've equally considered the Judiciary's Bail and Bond Policy, Guidelines 2015, and parameters to apply. There is no doubt that the suspects before this court are facing the suspects, whether facing charges in Kenya or outside, retains all their constitutional rights, and these include rights to bail. It is clear from the documents filed by the respondent, by the state, that the respondents were indicted in the United States of America. This, according to the prosecution, is compelling reason to deny, as they may escape, considering the seriousness of the charge they are facing. I also take note of the fact that the application before me is procedural in nature. At this stage, the court has got no powers to deal with merit or demerit of the case. And in the case of Juma vs. Republic, which is a criminal revision number E018 of 2022, the respondents who are already indicted in the United States of America by United States Court USC for Central District of California, and the charges were conspiracy to wire, fraud, and aggravated identity theft. The High Court sitting in Milimani, while granting the respondent's bond, observes as follows, and I quote, "In addition, I subscribe to observation that seriousness of a charge is reduced from punishment to be imposed if the applicant is found guilty. Thus, where punishment is heavy, there is high possibility and incentive for an accused person to abscond. In the applicant's case, I'm not persuaded that the extradition proceedings are of high gravity to warrant denial of bond. The extradition proceedings should only be limited to the process and requirements of extradition, and by its extraditing country. Even taking into consideration the nature of the offenses the applicant is to face before the United States District Court, I find the same will attract sentence of 20 years in total. In fact, the sentences are outlined for specific offenses. Also, it's upon that court to decide on what sentence the applicant should serve if found guilty. In that case, there is not compelling reason to extinguish the applicant's right to bail in extradition proceedings, which are just procedural." End of the quote. I've equally considered the case of Director of Public Prosecution versus Bybar and two others, which is a criminal revision, A116 of 2023. The respondents were required in Tanzania upon requests to the Republic of Kenya for extradition. The High Court sitting in Kibera affirmed granting of bond, but varied the terms. Looking at the issues raised, the maximum penalty is in the region of 30 million if convicted, and there are the issues of mitigation. Considering the above cited cases, the figure alone cannot be a compelling reason to deny respondent bail. Again, no evidence was presented to show that they are flight risk or they will interfere with witnesses. In conclusion, my finding is that there is no compelling reason that has been given to warrant denial of bond pending extradition proceedings. The respondents are granted bond terms in the following terms. Each of the respondents is admitted to a surety bond of Kenya shillings 5 million and a cash bail of Kenya shillings 1 million, each to avail 3 conductspersons, and they are all directed to deposit their passports in court. The case will be fixed for further directions on the 31st of March.
Much obliged, Your Honor.
Most obliged, Your Honor. Maybe a last order on place of remand pending the processing of the case.
Yeah. Before the file is placed off.
Let me.
Yeah, for the second respondent, the passport is in the hands of the officers. So that condition should be applied.
Respondents will be held at Kileleshwa Police Station pending processing of the bond.